Thank you, Senators. Honourable Senators, we are meeting to begin our study of Bill C-14, an act to amend the Criminal Code, the Youth Criminal Justice Act, and the National Defence Act on bail and sentencing. For our first panel, we are pleased to have with us the Honourable Sean Fraser, Minister of Justice, Attorney General of Canada, and the Minister responsible for the Atlantic Canada Opportunities Agency. He is joined today with officials from the Department of Justice, Mr. Owen Ripley, Senior Assistant Deputy Minister, Policy Sector, Matthew Taylor, Senior General Counsel and Director General, Criminal Law Policy Section, Miriam Wills, Counsel, Criminal Law Policy Section. Welcome and thank you to you all for joining us today. Minister, thank you for coming today. We'll begin with your opening remarks, and then we'll move to questions from our senators. Sir, the floor is yours for 7 minutes or so.
Okay, I'll do what I can to come in under time to save more time for the discussion if possible. Merci tout le monde, c'est un grand plaisir d'être ici pour discuter.
Thank you. I'm delighted to be here to discuss Bill C-14.
Which is clearly a major political priority, not only for the Government of Canada, but for Canadians and communities in every part of the country. The government is seized with public safety as a top priority. You'll note that a significant number of pieces of legislation touch not only on criminal law reform, but on public safety since the new government has come into office. Before I get too far into the specifics around Bill C-14, I think it's important to understand that this bill is part of a broader strategy to address public safety. Nous avons une stratégie pour avancer la sécurité publique.
We have a strategy to promote public safety under 3 key pillars. First of all, we want to advance reforms to reinforce criminal laws throughout the country. The second pillar is to support people who are suffering from crime.
CMP officers. Of course, that includes border officers. It also includes community organizations who are supporting victims who may be fleeing violence. It also includes making sure that law enforcement has the tools that they need to investigate, to prosecute, and importantly, to prevent crime. But the third pillar to me is the most important if we're going to see long-term progress when it comes to ending violent crime in Canada, which is to make the upstream investments that we know will improve community safety over time. In this regard, I'm talking about investments in affordable housing, investments in mental health and addictions, investing in young people who may be at risk. And with this three-pronged approach, j'ai beaucoup de confiance. Nous avons d'opportunités pour faire.
I have a lot of trust, and I think we'll have opportunities to make a difference.
Bill was not something that was determined behind closed doors on Parliament Hill. There was significant engagement with law enforcement, with provincial governments, with stakeholders in civil society, with those who've dedicated their lives and careers to understanding public safety and some of the solutions that we can put in place to address them. The bill, although it includes many dozens of measures, I think it's 84 total distinct changes that are being proposed to the criminal code. It could be complicated if we want to get lost in the weeds, but to simplify things, there's 2 main things that this bill does. Strengthens the bail system in Canada and strengthens sentencing regimes in Canada. When it comes to the bail system, the first change that I want to draw your attention to is important changes to what's known as the principle of restraint, a principle that was advanced by the Supreme Court of Canada and codified in the Criminal Code. We, in response to concerns that we heard in community, including from law enforcement, are making changes to clarify the principle of restraint, to make it absolutely clear that the court has a responsibility to protect the public safety imperative, and if they do not have the ability to protect public safety, then they have grounds for detention under this particular legal test. There's other important changes that are being made in this particular piece of legislation, including the factors that we want courts to consider when it comes to making decisions with respect to someone's bail hearing. This includes ensuring that we look not only at the seriousness of a given charge that an accused may face, but also that they consider the history. If an individual has been repeatedly charged with such a high volume of charges that it would call into question the public's faith in the administration of justice, we want the court very specifically to consider that as well. There are other factors that we can get into if you wish, but in the interest of time, we also are asking the courts to look at different conditions they may place on a person's release that are often tied to the nature of the underlying offense with which a person is being charged. This includes non-communication orders for people who may be tied to extortion rings or organized crimes. It can have limitations on possession of a break-in device for somebody who has a history of breaking into homes or stealing vehicles. You'll see a number of different conditions that are set to attach to a particular charge, given the nature of that charge. Importantly, in this bill, there's a series of offences that we have determined are appropriate to advance what's known as a reverse onus. I expect most of you are familiar with the concept, but for those who, millions of fans tuning into CPAC at home, I'd suggest that this is something that we should explain. Normally, the burden rests with the Crown to determine why a person should be detained. For certain charges, particularly those that we believe are likely to involve repeat offenders or that are going to be tied to criminal organization, we are making certain changes to say that the accused must demonstrate why they ought to be released and on what credible information. The kinds of offences that we are going to subject to a reverse onus in the current draft of the bill includes a violent auto theft or auto theft tied to organized crime. Similarly, home invasions that meet that same threshold. Certain trafficking and smuggling charges, assault, including sexual assault, particularly where it involves choking or strangulation, which we've seen in certain cases. There's also new measures around violent extortion and changes after a person has been convicted but before they have been sentenced. In addition to these changes, en addition de changement de système de mise en...
In addition to this change to the bail system, we need to strengthen sentences for more serious offenses.
I'm
sorry for the quality of my French, but I will continue in English because of technical difficulties.
We want courts to consider at sentencing, including if there is a history of violent repeat offenses, including a crime that's committed against a first responder who we depend upon for our community safety, including participation in organized retail crime or crimes that may have a low dollar value but nevertheless have a significant economic consequence by virtue of targeting our essential infrastructure. There are certain new offenses that we wish to subject to consecutive sentences rather than concurrent sentences, particularly those that involve extortion cases that involve arson, auto theft and home invasion, and again, violent repeat offenses. There's a series of other changes that we're making, including limiting access to what's known as conditional sentencing orders, typically thought of as house arrest, for certain serious crimes, including sexual offenses, and in particular, sexual offenses committed against children. There are other changes that we are making of a similar nature when it comes to the orders that a court may issue, including restoring the ability of courts to impose driving prohibitions where there are charges, or rather convictions for manslaughter or negligence that may cause death. There's a series of other administrative changes that are being made to the bill, but in the interest of saving time for discussion, I would just conclude with my thanks for what I'm sure will be a rigorous study. Although we do want to very quickly advance laws that will help deliver better safety outcomes to communities, I do want your help to get this bill right. To the extent that you learn through your rigorous study that there are improvements that will advance public safety in this country, and know that I want to consider them with an open mind. I'm grateful for the work of Parliament. I believe in the value that both chambers offer, and look forward very much to seeing the feedback that I receive after a thoughtful and rigorous consideration of the bill. Merci tout le monde. C'est un plaisir d'être ici.
Thank you. A pleasure to be here.
We'll now proceed to questions from the members. Colleagues, as chair, I will keep the questions and answers to 4 minutes per member. We have 14 senators here today, so I'll have to rule fairly succinctly on that. I see we have Senator Morrow, the government leader in the Senate, and Senator Delphine, the sponsor of the bill. Hopefully we'll be able to make sure that everyone gets a chance to ask a question. I thank the members in advance for their courtesy and cooperation in observing this time limit to ensure all members have that opportunity. I will now ask to start with Senator Batters, and there is a list, so if others want to add to the list, it will go in this order. Senator Batters, Senatrice Melville-Deschênes, Senator Prosper, Senatrice Saint-Germain, Senator Dillon, Senator Wells, Senator Simons, Senator Pate, Senatrice Udar, Senatrice Clement. Senator Batters.
Thank you. Thanks, Minister. I'm the critic for the bill, so I'm glad to hear your openness to potential amendments. You introduced Bill C-14 in the House of Commons last October, and by that time the serious crime of extortion had already been increasing at an incredible rate in Canada. So the scourge of extortion was already well known, and you mentioned it a number of times. Perhaps you might have mentioned it as many times in your opening statement as the bill mentions it, because the bill only contains minimal measures to deal with this issue. Minister, extortion has shot up 330% over the last 10 years. So why didn't your government use the legislative measure of Bill C-14 to combat it in a more serious way?
Thank you for the question. And first, let me express my strong agreement that extortion is a very serious problem that needs to be addressed, and we need to use a series of different tools. There are some tools included in this bill that are meant to deal with extortion, particularly violent extortion, both on the sentencing and on the bail side of the equation. But in addition to strengthening both sentencing and bail rules when it comes to extortion, when we actually engage with law enforcement, what they ended up telling us was, yes, there are changes you can make to bail and sentencing, but we do have significant sentences up to the maximum life sentences for repeat extortion in particular, and for mandatory minimums, particularly when there's a use of a prohibited weapon. But overwhelmingly, what we heard from law enforcement was what they actually need is not just more tools to punish people after conviction, but more tools to prevent extortion from happening and to bust extortion rings. We're actually dealing with some of these issues through what's now Bill C-22. It came initially in the Strong Borders Act, Bill C-2. There were certain changes that we wanted to make to accommodate the feedback we heard during the consultation phase. And we heard loud and clear that having a lawful access regime is one of the top tools that law enforcement needs to understand when extortion is happening, why it's happening, and who is involved, so they can enhance their investigation and potentially bring down massive rings which are responsible for a vast majority of examples of extortion. So there are significant measures in this bill, both on sentencing and on bail, but more specifically, I just want to point out that it's part of a broader strategy, including getting the tools to law enforcement that they've asked for, which is included in a separate bill, which will, I hope, arrive before the Senate.
Okay, Bill C-14 limits the application of conditional sentence order, house arrest, for only certain sexual offences, including for certain sexual offences against children. Minister, why does Bill C-14's new exclusion of conditional sentences for sexual assault, sexual exploitation of a person with a disability, and sexual offences involving a victim under 18 years of age apply only when the Crown proceeds by indictment? This is very concerning because a sexual offence conviction, and especially a sexual offence against a child or person with a disability, is serious, period. Why is your government leaving the door open to house arrest sentence just because the Crown proceeds summarily?
So, look, thank you for this. And there's an interesting interplay between the measures included in this bill in terms of conditional sentencing orders, but also that will be supplemented by the restoration of mandatory minimum penalties that are coming with a subsequent bill that the House of Commons has just commenced its study on. And I've got a high degree of confidence that as a result of the two bills moving through on parallel tracks, that we're going to see significant changes when it comes to sentencing for sexual crimes more broadly. We've also worked very closely with members from different parties, including Mr. Caputo, a Conservative member, on other measures that will strengthen the ability of the legal system to respond to crimes of a sexual nature, in that instance, particularly in an intimate partner violence context.
And
Senatrice.
okay, second round, please.
Okay, thank you. Senatrice Melville-Deschênes.
Bonjour, Monsieur le Ministre.
Good afternoon, Minister. Bill C-14 limits the availability of prison sentences, conditional release for serious sexual crimes. I agree in principle with this measure, but according to the Criminal Lawyers Association, conditional sentences are never imposed for serious sexual assault since the Pearson Supreme Court case. So what's the use of that measure if already those who are convicted, those who are convicted do not enjoy a conditional release?
Merci. No moment.
You are right. It is rare for serious crimes, for those accused of serious crimes to benefit from that measure. But when I looked at the convictions in some cases, there are always surprises. It's possible for a judge to come up with a decision which is different from the House of Commons or Senate's priority. It's possible to change rules to
to what's going to happen in the future. There have been other bills that have enjoyed the support of both the House of Commons and the Senate through previous parliaments, including one that rendered conditional sentencing orders inapplicable for advocating genocide or attempted murder, which is not, in fact, playing out in the real world in most cases. But nevertheless, I think it's important that we have laws that reflect the priorities of Parliament collectively and to demonstrate a strong signal to deter future behavior that we can say there are going to be serious penalties should you commit a serious act.
Okay, thank you.
Okay.
Senator Prosper.
Thank you, Chair, and welcome, Minister. Minister, Indigenous peoples represent approximately 5% of Canada's general population, yet account for over 30% of the federal inmate population and over 50% of federally incarcerated women. This is from DOJ's own statistics. Before Bill C-14 was introduced, what specific analysis did your department conduct to project how the bill's tightened bail and sentencing provisions would affect that existing over-representation? And if you have done this analysis, would you table that analysis with this committee?
Yeah, thank you. So, but first of all, let me just agree strongly that overrepresentation amongst incarcerated populations in Canada is a very real challenge, and Indigenous Canadians, Black Canadians do face a degree of overrepresentation that needs to be addressed. We do, when we conduct an analysis of these bills, include a gender-based analysis plus, which looks at some of the different impacts that some of these potential changes could have on different communities of interest, including Indigenous peoples across Canada. The point that I think is important, though, as we seek to, and this is my own point of view and philosophy at work to some extent, when it comes to our criminal laws, the starting point for me is we have to ask ourselves what is going to promote public safety. When we understand what the rules are that are going to deliver the public safety outcomes that we wish to experience in Canada, we then need to say, with open eyes, understand that there are potential downstream impacts of the changes that we make and make appropriate accommodations. When it comes to the kind of work that we do in this space, we would look to the use of GLADU reports or impact of race and cultural assessments when you're seeking to deal with sentencing regimes. We also want to ensure that we have programs at play in the long term that help build healthy and more equitable communities to deal with challenges that have emerged over decades that certainly demand our attention. My sense is that there are many things that we can in fact are doing, can do, and would benefit from your advice on, separate and apart from the criminal law reforms, to ensure that we have supports in place to combat overrepresentation. I know in the interest of time, I don't want to talk out the clock on you. I do believe the officials are going to be here for an additional hour after my testimony, and I would welcome continued questions on that subject.
Any more time, Chair?
You have a minute.
Yes, you mentioned GLADU reports. I'm just wondering, do you think Bill C-14 creates sort of mechanisms that somehow fetter judicial discretion with respect to a judge's ability to conduct meaningful GLADU analysis at the bail stage?
That's not my point of view. However, I would invite, without reservation, questions to expert witnesses on this regard. And should you determine that there are recommendations for the government inside or outside of this legislation, I would welcome your expertise and advice in that regard.
Thank you, Minister.
Senator Dillon.
Thank you, Chair. Thank you, Minister, for being here. And thank you for your work on this. I know this is an important bill, certainly for British Columbia, and I know the Attorney Generals for British Columbia and Ontario have also shared their support for this. While I agree that there are times, and I'm referring to Clause 70 of Bill C-14 with respect to the youth identity disclosures in urgent situations, and I understand the reasoning behind it, but this is quite a departure from usual protections that we offer youth in the youth justice system. What safeguards are we putting in place to make sure that when this power is used by law enforcement and police, and when it's used, it's truly necessary, and not in situations where informations are incomplete or later turns out to be wrong? And is there opportunity to put in place some sort of a review post-event to learn from these measures being put in place, and also continuing to better them as we go along?
Thank you for the question. And just before I answer in a detailed way your specific question, your preamble included letters of support from different provincial governments. Some have written this committee, I understand. Every premier in the country has publicly endorsed this bill and asked for its swift adoption, in part because they were involved in the ideas that we have embedded into the bill. Some of them I can point very directly to which provincial counterpart has recommended them, and that is a particular point of pride given the nature of the Federation at work and collaboration with different provincial governments. On the issue of the identifying information for youth offenders, there are safeguards in place. First and foremost, this is only for urgent situations, and at risk of using certain dramatic examples, coming from Nova Scotia, I know what it's like to have alerts go out about mass casualty playing out, and getting information about an offender in a given set of circumstances that might save lives is something that I believe is important, though I think it will be used rarely in the context of a youth offender. In addition to having the urgent requirement, there are other safeguards in place as well, including having only access to law enforcement for publishing this information, having potentially criminal penalties for people sharing the information in an unauthorized way, including a requirement that a court order be obtained if the publication remains online for more than 24 hours, including a requirement that the publication be removed. Of course, in the digital world, there are always footprints left, but these are the kinds of things that we wanted to put in place to offer maximum protection and only allow this unique change in the law in circumstances where there is an urgent risk for serious harm to befall the public as a result of an emergency playing out in real time.
But are there any measures post-event that would require law enforcement to have an independent review of their actions to better address or look at any gaps or errors that may have arisen? Because I think every event, as you say, are going to be rare. And as we move through those events, these rare events, the rest of the country should learn from them as well.
Just because something's rare doesn't mean we should say there shouldn't be accountability. The measures that we've put in place were protections that I thought adequately protected the individual who in some circumstances could potentially be possibly falsely accused of carrying out an act of the nature that I've described. If this is an item that the Senate wishes to pursue, and there's testimony from those who appear before you as witnesses that would support further changes, I do expect, as a matter of practice, law enforcement, as you would probably know better than I ever could imagine, this typically would happen internally, but if we want to explicitly adopt requirements to that effect, so long as we have expert testimony that backs up a recommendation or a proposed amendment, know that I would welcome your feedback in that respect.
I appreciate that, Minister.
Senatrice Saint-Germain.
Merci, Monsieur le Président. Monsieur le Ministre.
Thank you, Chair. Mr. Minister, the bill provides that for some offences related to theft, the court should consider as aggravating the fact that the accused committed the offence to sell or to exchange the stolen items. And in your preamble, you used the expression organized retail crime. My concern is implementation of the bill, particularly because it could have a disproportionate impact on homeless people, a population that is increasing in Canada, and where we find this practice as a common factor because they go and steal to get money. My concern also has to do with the implementation of the act or bill, not only at the level of the courts, but amongst law enforcement officers who will have to implement the law. Do you think there will be safeguards required when it comes to regulations? Could we do more to make sure that homeless people are not excessively arrested as part of this article section?
Juste avant de commencer avec les...
Before I start providing a direct answer, let's reflect, as I did in my speech. It is more important to address the social factors that contribute to violence in our communities, including specifically investments in affordable housing, because there's a connection that is clear. When someone doesn't have housing, the probability for the person to experience other consequences, including participating in criminal activities, is a consequence that requires being addressed through investments, social programs, social housing, and so on, affordable housing.
Referred to as organized retail crime. To the extent that a person's individual circumstances are at play, judges are required to consider all circumstances when they're going to adopt a sentence that is fit in the given scenario that may arrive before the court. But the harm that we're trying to address, it has nothing to do with having harsher sentences for people who are not posing a continued danger to our communities. We want to have the court look at this particular issue primarily because we are hearing about rampant instances, particularly in downtown environments, of repeat criminals who consistently are committing crime to the point where businesses are being forced to close, where customers are leaving our downtowns because they fear for their personal safety, and because oftentimes people are being recruited into criminal organizations, whether they know it in the instance or not, to participate in a much broader scheme that is targeting businesses for the economic gain of organizations who continue to perpetuate crime. If you think that there are nuances to the drafting of the legislation that will better target people who pose a public safety threat, I'm interested in your feedback. This is a theme to some of my answers. This study is not meant to be a rubber stamping process on the government's draft of the legislation. I want the best public safety outcomes, and if it means that the legislation may require a few more weeks as we deal with proposals from the Senate in the House of Commons, but it yields better public safety outcomes for the next generation, then it would be worth the wait. So to the extent that you think that we can better tailor these aggravating factors to target people who pose a public safety threat, know that I would welcome your perspective in that regard.
Thank you for that, Minister. If there is time, I'll go in a second round.
Okay, second round. Senator Wells.
Great. Thank you, Minister. Appreciate your comments on focusing on the best outcomes for public safety. My questions are focused in that area of, first of all, looking at the foundations of the evidence that has informed the government's assessment of the need for these bail and sentencing reforms exactly in relation to public safety. So, how did you build the foundation and the evidentiary foundation to determine that this bill was going to, produce the best outcomes?
Yeah, so I think the starting point in this question for me is that we have some data in Canada, but it's not great. To be honest, we have the crime severity index that Stats Canada generates each year, and we have seen, leading up to 2024, a significant increase in crime across Canada. And I think we have to understand that that needs to be addressed. There has been some positive trends over the past 2 years, although the 2025 numbers are yet to be finalized. we started to dig in to figure out how can we better break this down. The federal government, not having conduct of the administration of justice, doesn't have all of the information that comes before typically provincial courts at bail hearings, and the consistency with which data is collected as between different provinces is unpredictable, if I'm being generous, but there's really a paucity of data depending on which part of the country you're operating in. There is some information going sometimes municipality by municipality that will demonstrate that there are certain challenges we have around high volume offenders who repeatedly commit crimes, but it's not as though there's a perfect national data set that we can operate from. So in the absence of perfect data, but knowing that there is a problem, we engaged in a period of consultation that dealt often with the people who were involved in enforcing the law, policing organizations primarily, but also the levels of government who are charged with the administration of the justice system in their given provinces. And the consistency with which we were hearing the same story over and over that was not contrary to the national data that we do have demonstrated there were certain problems that we needed to address, particularly when it came to violent repeat offenders or those tied to criminal organizations, when it came to bail and certain kinds of sentencing regimes. So I don't want to presume that I've hit all of the elements you were looking for, but if you want to follow up, I'd be happy to further engage.
Sure, I'll probably dig in with your officials maybe on I'm glad you mentioned sort of the data gaps that are existing and the challenges and the issues of collecting the information. Of course, we want to make sure that legislation is always the best evidence informed based on what we have access to. So do I have a minute? Great, thank you. Can you speak a bit about the government's understanding of the profile of reoffending while on bail and how that has informed the design of the legislation?
So look, I want to be careful not to. Offenders are not a monolithic group, and it is so important that in every case the individual circumstances of an offense be considered, and that we protect the ability of the court to do that. I don't know that it's helpful for me to profile offenders as a class of people, but we are seeing patterns emerge when we talk to law enforcement in particular about the kinds of problems that they see. We see in different pockets of the country home invasions and car thefts in particular often involve, it is rare that I've come across a police force who says that we deal with routinely with individual people who do something along those lines once and they never see them again. Repeatedly we hear that if there's a neighborhood that sees several vehicles go missing, they will often point to the fact that there are certain offenders that have been responsible for multiple auto thefts. The same story plays out when we engage in conversations with home invasions, which can be very complex because it's often part of a larger organization, not just an individual person. There's a different issue set that comes up when you're dealing with downtown business associations who tell you that the problems that they're having are not necessarily violence toward an individual, but we'll see repeated examples of shoplifting or vandalism or behavior that may not be violent, but may be harassing towards customer bases. So I only use these different examples to point out that depending where you are in the country, the nature of the community that you're in, and the nature of the offenses that law enforcement are raising with us, the profile of the offender could be widely varied.
Thank you. Senator Simons?
Thank you very much, Minister. Reversal of this might be especially for nonviolent crimes and for young offenders, or even for offenders who are adults and young. The entire power of the state is ranged against somebody who may not have access to counsel, who may be self-representing, and who is then put in a position where instead of the state having to prove that they are a risk, they have to prove something very difficult, which is that they are not a risk, which is a much harder thing to prove, especially if you don't have access to counsel. Given that our remand centers in Canada are already full to bursting, in my home province of Alberta, 85% of people in provincial custody are remanded. Is there a concern that if you make bail this much harder to get, particularly for nonviolent and young offenders, that we are going to see a situation where our remand system simply cannot handle the number of people who will be remanded, which will then have the knock-on effect of ending up with people having more Jordan situations, or more situations where they get huge amounts of time credited for time in remand, which is generally very unpopular with the public?
Thank you, Senator Simons. You've raised two issues, one on the downstream impacts of the changes and one substantive on the changes themselves. In general terms, I believe that the normal rule should apply where the Crown bears the onus of demonstrating why a person poses a public safety threat, may not show up for their hearing, or that their release would call the administration of justice into disrepute. There are certain examples where we've made a decision, and perhaps it's obvious, but as the minister, I'm supportive of the reverse onuses included in this bill.
I'm assuming you're supportive of your own legislation. I think that's a given.
Yeah, and the reason why is because there's certain, really two categories of crime that are very problematic. The first is where you are dealing with violent repeat offenders, and we believe there's a higher risk to the public safety where that violence could continue. The second, particularly when it involves auto theft and home invasions, it's because some of these offenses are tied to criminal organizations and line the pockets of organized crime who can potentially perpetuate crime with the proceeds of the sale of what's been stolen from a person's home, or the sale of a stolen vehicle. The systemic concern that you've raised is important to address. This is where we need to make sure that we're engaged with provincial governments, who obviously bear the responsibility downstream to deal with some of these issues. Every province that I've dealt with is asking for these changes. Every one of them that has made a request to that the federal government implement these changes has heard from me personally in our conversations that this is going to put additional responsibilities on a system that in some provinces is struggling more than others. But to a person with my counterparts, they nevertheless wanted to move forward swiftly with the adoption of these changes. There are potential challenges that we should have, but my sense is, back to my earlier comment, if we start from the frame of promoting public safety with the criminal rules, then we need to work to ensure the systems are resourced. This is not the federal government saying, don't worry provinces, we're going to step in and deal with this for you, but there is a message that is well understood that to the extent that there are downstream impacts on the system, that we expect the provinces are going to make good on their responsibility to properly fund the systems.
I expect the bail system would work better in general if the bail system were better funded, if we had more funding for justices of the peace and judges, if we had more funding for duty counsel, if we had more funding for legal aid. I mean, presumably what people are worried about is that judges and JPs will make the wrong decision and let the wrong people out. Would it not be useful to fund that process so that people had confidence that when someone is granted bail, it's done appropriately, rather than creating a situation where you have people... I understand organized crime is bad, but the individual young foot soldier who boosts a car should not necessarily be made the scapegoat for, you know, an organized crime family who are deploying him. It seems to me that if you want to put the very bad people away, it's not the guy who steals your car who is the problem.
It may depend on the circumstances, but certainly in some instances, I take your point. And I'm a big supporter of opportunities to divert, particularly with young offenders, people away from the justice system. Because we have to remember, particularly with young offenders, people who commit offense and receive a criminal sentence, even if they're incarcerated, one day they are released. And we do need to protect against having a more dangerous person being released into our communities. But we also have to respect the jurisdiction of different levels of government, and Canadians have an opportunity to hold governments accountable should they not be running the systems for which they are responsible effectively. When we obviously need to collaborate and understand the perspectives of different levels of government in one another's area of jurisdiction, but I don't think it would be appropriate simply because the federal government has responsibility for the criminal code anytime we make a change to usurp the jurisdiction of a province that we perceive as making inadequate investments. I think that's a responsibility for provincial governments and their voters, to the extent they fail to do a good job, should hold them accountable.
Senator Pate.
Thank you very much, and thank you, Minister. It's always heartening to hear ministers talk about the need for upstream and preventative measures like income supports, housing, health, and social supports. In this area of criminal law and sentencing, Rarely do you see an evidence-based approach, and rarely do you see that as a priority, however, and this is one example I would suggest. Successive ministers of justice have admitted that there's inadequate data to assess the impact of legislative changes restricting bail. And although much has been made of the fluctuating detention rates, we know that since 1998, as we've seen overall uses of more restrictive bail measures, we've actually seen the overall crime severity index and violent crime severity index fluctuate, but mostly downward since 1998. And the figures are that break and enter offenses have declined 75%, motor vehicle theft has declined 57%, with no connection or targeting through bail system during this time. So given that reality, and given that the last time we talked about car theft before this committee, we actually heard from car manufacturers that they have inexpensive means of preventing car theft. It's obviously in also car manufacturers' interest to have cars stolen, quite frankly, so that they can replace them, as people who have their cars stolen are often called right after by their car company to see if they want it replaced. I'd like to know very specifically what data you do have. It's politically expedient to go on these kinds of measures, but we understand that you and your department have repeatedly sought data. What data have you actually received, and how has this supported this measure that you're taking forward? So I understand politically that the provinces want it. I understand that in these moments, evidence is rarely the basis for these. It's often what seems, it seems to respond to people's emotive responses, and we don't like seeing homeless people. We don't like seeing more kids being recruited. What are these measures actually going to do, and what do you predict in 6 months or a year we'll see in terms of, besides more people in bail or in jail, what we'll see as a positive result?
Okay, a lot to unpack in a short but content-filled question. First, that was not meant to be in jest. So there's several issues, and I'll try to address each that I can in the time. I expect we will have to have follow-up conversations to fully address each of your concerns. So first, on the evidence, I would be legitimately curious to compare based on your starting point. If you go back several decades, you're right, there was a period in Canada's history where crime rates were higher than we've seen more recently. But we have seen in the decade starting about 2014 up to 2024 an increase in the rate of crime in Canada, with a downward trend since 2024. Trend may be the wrong word, given that we really only have 1 year of data to consider, but based on regionalized data coming in from larger urban centers, I expect you'll likely see a flattening or downward trend that will continue. There is some information we have based on the measures that we have put in place, but it's often very localized. So if you look, for example, at the investments that were made in the Peel region at the intermodal facility that were fairly inexpensive by public safety standards, we've seen a sharp reduction in auto thefts as a result of that and other measures that were put in place. Those kinds of things do work, but they are only part of the story. When I actually engaged in areas where we may not have perfect data, I believe gathering qualitative data can also be a useful exercise. And a lot of the recommendations that you see come from common themes that were expressed from law enforcement who are on the ground telling me about the reality that they're experiencing. Sorry, you wanted to interject.
Yeah, I'm just curious, as when the provinces and territories came to you with this request, would not an obvious response have been to say, produce the data that backs this up? Because my understanding is the federal government is having difficulty getting the data. Successive ministers of justice have said that, in fact.
So it's that conversation is happening in parallel and continues today, and we have I think we've issued the request for proposals already, and we've had 8 different provinces express interest in having support from the federal government to improve their data collection. That work has not started because we're early in this process. So as part of my effort to make changes now, I do want to empower different levels of government to, in a more uniform and comprehensive way, collect data so we can understand the impact of the measures that we're putting in place now if we monitor the shifting rate of crime in given communities over time. The fact that we don't have perfect data now, in my view, doesn't justify not taking action when we have such consistency in the themes that need to be addressed from law enforcement, from municipalities, from business associations, from provincial governments. If I heard 100 different things from 100 different stakeholders, I probably couldn't make any conclusions reliably from that. But if we do have some evidence that over the course of a decade, the overall rate of crime has increased, and there's consistent themes that come out of the conversations with the different parties I've just alluded to, we do have some information on which I believe we can make policy decisions that we would expect to have a positive impact. But in my view, we also need to measure them, and that's why we're engaging with provinces now to have the federal government be a funding partner on data collection.
Second round, please.
Thank you. Senatrice Udar.
Merci, Monsieur le Président. Merci, Monsieur.
Thank you, Chair. Thank you, Mr. Minister, for being with us this afternoon with your team. Let me take you back to the end of the Act, amendments of the law for amendments of the Youth Act when it comes to violent offenses, past assessment of release, the possibility for the police to publish the identity of teenagers, something you referred to a while ago, and tightening of the bail system in case of breach of conditions for a teenager or youth. In the analysis that you did you identify any dangers that these changes could bring when it comes to the over-criminalization, when there's over-detention, and also that it could also affect the education of these children? What guardrails should we rely on to reconcile at the same time public safety with the rights, presumption of innocence, and particularly the need for reintegrating the youth?
So on the change that you're referring to, if I understood correctly, there are some limiting factors that give me confidence that the consequences you may be concerned with will rarely arise because of the nature of the circumstances under which the identity of the youth could be published. Again, we're dealing with urgent situations where it's necessary to publish the identity of the potential offender in order to protect the public safety. The kinds of scenarios that I am envisioning are the horrific scenarios that we've seen play out with the mass casualty in my own province, more recently with the tragedy that played out at Tumbler Ridge. To the extent that we believe that we can save, in some instances, a significant number of lives, we do want to make that the top priority. There are protections that we've put in place to very quickly have the information removed, to prevent others from needlessly publishing the information under risk of criminal penalty for inappropriately publishing the information. To the extent that there are concerns that are unaddressed with the protections that we put in place, I'd extend your offer, as I have to one of your colleagues, to thoughtfully advance proposed amendments to address your concern. But in the circumstances where we are dealing with someone who is in fact on the verge of carrying out a serious infraction that could endanger life or limb of an innocent bystander, that has to be the priority. And to the extent that there may be consequences to an offender being identified, that's something that we should perhaps manage, but certainly as a subservient priority to the safety of the potential victims of an emergency situation of the nature I've described.
Senatrice Clement.
Mr. Minister, it's good to see you. It's good to see all of you. I'm glad you have said a few times now about an openness around amendments, because I see Mr. Ripley sitting next to you, and every time I see you, I think about C-11. And for the newer senators, that was a massive endeavor. But what we did at committee is that we hashed out those amendments. We worked with government officials to negotiate things and actually get amendments passed at committee. I'm just saying, personally, it's been a little challenging the last few weeks making amendments on the chamber floor. And so I'm hoping that we can really work well at committee together. So thank you for those comments. Good to see you, Mr. Ripley. Couple of things. So the Black Justice Strategy. I'll just read you a quote that went into that strategy from a Black participant. Jaku Conbit is a local organization I have contact with. And this is a quote: "I have very little faith in the system's responsiveness to the needs of Black victims and its ability to be fair and just to accused Black people." So you've got a lot of challenge there, and I'm trying to understand how the government uses or doesn't use a Black justice strategy or an Indigenous justice strategy to inform the way that you draft legislation. Because our communities are having concerns about C-14. Are you taking into consideration all of these many reports that many smart people provide to the governments of the day to help inform policy and legislation?
Look, thank you for the important question. Maybe just before I address it, I've never seen more inside joke than someone saying C-11 and having a room of parliamentarians immediately laugh. But sure. And look, let me just reflect your gratitude back. You would be doing me and communities across Canada a favor if you can strengthen the impact that this bill is going to have on public safety, and to the extent that you propose amendments, each and every one of them will be considered in good faith. That's a really excellent question that you asked about the Black Justice Strategy and the Indigenous Justice Strategy. There are different measures that have been specifically enumerated that we are advancing, not exclusively in one piece of legislation for another. If the House dispenses with Bill C-16, which will come here, you will see a direct recommendation around embracing restorative justice and the Protecting Victims Act as a recommendation that comes from the Black Justice Strategy, for example. The other changes that recommendations that we see coming out of these are not exclusive to Canada's system of criminal laws, but sometimes address some of the broader social issues that we need to address if we want to strengthen justice insofar as it impacts different communities in Canada. So and some of them are very directly at issue, though not necessarily the subject of legislation. I think about investments that we make in impact of race and cultural assessments, huge with the African Nova Scotian community, who have become pioneers, and I should say thank you to the African Nova Scotian Justice Institute for their work in helping lead this file. But you were right to point out, I think, the comment as well, that overrepresentation is not just a problem of incarceration, it's also a problem of when you look at the victims of crime. There are certain communities that are over-policed. There are certain communities that are under-policed. The likelihood that a person may be charged for a given set of behaviors changes depending on the community from which they come. The length of the sentence, you understand the point. But I think if we're going to address these, we do need to look at the recommendations that come from these strategies, not just as they impact our proposed criminal law reforms, also as they impact our criminal law reforms, but we do need to look at what upstream investments can we be making, what training can we be providing to actors within the justice system, how can we better collaborate with provincial partners where there is a role for the federal government to fund particular activities. So there's not a simple answer to these very complex social problems, but we do, when we're advancing different pieces of legislation, consider the advice that comes through the steering committees of these strategies, but also when we're advancing programs or policies that may not require legislation. So it's a bit of a complicated answer, but what it boils down to is those strategies are extremely useful because they've really taken more of a whole of society approach to how we solve inequities that exist within the justice system. And if we borrow the lessons from the good work that's gone into those strategies when it comes to the implementation, I do believe that we can achieve better outcomes for Black Canadians, for Indigenous Canadians, and others who may be disproportionately impacted one way or the other when it comes to the justice system in Canada.
Yes.
Yes.
Thank you. Senator Tanis.
Thanks. Thanks for being here, Minister. I just noticed that one of the amendments that was made at committee was a 5-year review. And we're starting to see a lot of 5-year review stuff. And I think that as a Senate, we're starting to realize that we're probably going to be the ones that are going to have to initiate a number of these 5-year reviews that are sprinkled around in legislation. So your comments and other concerns that have been raised here about data, I think it's important, and I'd love to get your view on, is there any chance that you could assemble some data points at which you are going to start tracking over the next 5 years? Even if you have to use proxy communities rather than every single jurisdiction in every single province, if you could spend a little bit of brain time on with your people on what are the proxy communities that are giving you data or could give you data effectively, even if you paid them directly to do it or contributed, so that we're not sitting here 5 years from now with the same story. Well, we haven't got the data and we're just listening to this guy or that guy, or this is working or this isn't working, and we're right back where we were. It would be great if there was some way to do that. And maybe the answer isn't asking every single province to sign on for every single community and you're going to fund it all, because there's a lot of steps in there. Any thoughts on what I'm raising?
Yeah, so look, thank you. And I'm sort of reflecting in real time only because I've not considered the idea of a proxy community. When I look at a data set, I would like to have some confidence that it represents the larger pool of data that is out there. And if we chose, for example, the Peel region has raised with me repeatedly the concerns they have around auto theft and home invasions, despite some progress in that regard. That lesson wouldn't necessarily apply in rural Nova Scotia, as Senator Prosper and I would know well. So to the extent we use proxies, I would want to be using them deliberately to illustrate a broader national trend to see if we're really having the impact we want. It may be a very good idea, though, because crime is inherently a very, very local issue, and solving the problem in one community in and of itself would be a very good thing. The challenge that we have in designing how the data is going to be collected is that we don't actually have the authority to collect it in most instances, so we do need a willing provincial partner. This is part of the work that's going on right now with the request for proposals that's been issued. I hope every province will avail themselves of the opportunity. I hope that we can have some standardization in the data collection. It may be practically or logistically difficult to get precisely identical data from each jurisdiction, not because of a philosophical opposition to data collection, but because the systems operate slightly differently in different parts of the country. One thing that I would benefit from, whether it takes place at the Senate or the House, is getting an understanding of what data we really ought to be collecting and measuring over the next number of years in respect of these changes. So the 5-year review will be most effective. If this perhaps is not appropriate for amendments in this bill, but if there was a subsequent study that recommended how best to collect this data, that would be extraordinarily valuable to me. Again, with the understanding that we would need to be collecting data that provinces are willing and able to collect and feed into a national data set.
Thank you.
That completes the first round. Minister, I have 4 senators that would like to ask another question of you. Do you have the time?
Yes. Sorry. I'm on duty in the House. Is it possible that I can maybe take like a question or two and beg forgiveness of the Whip's office? If we could maybe limit it, Chair, to 2 questions, because I am required to be in the House.
Yeah. Okay, so we will, our senators will go right as quickly as possible. Senator Batters.
Thanks, Minister. After I had asked for your government's gender-based analysis plus document on Bill C-14 for quite a while, senators did finally receive some kind of a 2.5-page document on this. And what I'm wondering is what was emailed to us by the bill's sponsor some sort of a summary of the actual GBA plus document that your government used in considering this bill at Cabinet? And if so, why don't we as parliamentarians receive the full document that your new government uses when we here in the Senate are expected to render sober second thought on legislation? And of course, we used to receive it when it was your old government. So also, this GBA Plus summary is not even posted online anymore for this bill, so the Canadian public can't see it. Why not? And again, your government used to do this. So given that this government, or this document, sorry, is called a gender-based analysis plus document, why does it make almost zero mention of female victims of crime and an analysis of Bill C-14's effect on them?
Thank you. Again, a lot of details to unpack. If I miss some of these and you'd like to follow up, no, I'd be happy to. So the document is a summary of what was heard when we and the ideas and items that were discussed when we were analyzing the different impact that the bill could have insofar as it impacts different genders and intersecting grounds of a person's identity. So it is a reflection of the conversations that we had when we conducted that analysis, and it is the gender-based analysis plus for this particular bill that you have in fact received. What's that?
The full document, not just a
There's
summary?
not some other document that we're hiding from the Senate. To the extent you want further information about how we've arrived at the final text, if you send a follow-up ask, I'll provide whatever we can. One of the things on your question about the how often it's referred to the victims of certain crimes in terms of the impact. What's that?
Yeah.
So, well, there's on a parallel track, we have another bill specifically dealing with the impact of criminal law reforms on victims. It's the Protecting Victims Act, I think appropriately named. You will see additional discussions within the GBA Plus for Bill C-14 in terms of the impact on the bill on female victims. To the extent that you wish the Department of Justice to further advise some of the expertise that we do have on the impact of the crimes included in Bill C-14 on victims, I'd be happy to share whatever information you're looking for.
Yeah, I'd say that whatever bill you're bringing forward on a criminal justice piece should have a victim impact as part of that. And why isn't this one online so that Canadian public can see it?
I don't know that there's a practice that's being continued
There
to
used
post
to be.
every GBA Plus online.
It used to be.
On request, I'm happy to provide any that come from my own ministry, but to the extent there's a broader change across government, of course there will be other actors in government involved in that decision.
Thank you. Senator Pate.
Oh, great, thank you. So in terms of data, if it's possible to get from your department what you've learned from the adoption and implementation of C-75 and C-48 and the lessons, and any data regarding rates of recidivism since those reforms would be particularly useful. I'm also interested in the, what the resources, the actual concrete resources are that are going out to counter this, because the billions of dollars that will be necessary to pump into the provincial system to fund this, you've already acknowledged could be used for upstream measures. And I'm curious how you plan to deal with the fact that remand conditions across the country are already being described in court cases and lawsuits as inhumane and are resulting in reduced amounts of time in custody, and how you're looking at the balance between deplorable jail conditions and shortened times in custody, and just, if we would be seeing this proceed the way it has so far, that will just result in another, similar reform like this coming down the pike in the future, if in fact people are getting out because of the deplorable conditions, which is an issue right now. So what kind of balancing of these, what kind of resourcing are you doing, and how do you see you'll be moving forward in the future?
Okay, there was sort of three categories that I picked up from the question. The first was on data with respect to other bills and the impact on recidivism. To the extent we can gather whatever information we have as a department, no, I would be happy to share. On resources, just so I'm clear, are you asking on resources that provincial governments would need to inject into the systems? Unaware of a dollar figure that it would take to address the downstream impacts of any changes in this bill. I expect that we will learn by application some of the impacts that will be required in terms of the resources within provincial justice systems. Of course, that'll have to come from provincial governments who would have a better sense of what that figure may actually be. Your final question is an important one, and I reflected on this a lot coming through the generation of the bill. And when I landed on the conclusion that the right approach from my perspective was to start with a framework that I believe will best promote public safety, it's not lost on me that there are challenging conditions, to say the least, in remand facilities across the country. But on the flip side of the coin, trying to solve the downstream impacts with the public safety framework you set in the code would cause you to say, well, maybe we should eliminate some of the protections that exist now in order to solve that problem. And that felt unnatural and the incorrect approach to me. So the focus that I had while being aware of the downstream impacts was to say we really do need, in order to protect public faith in the justice system, a set of rules that are designed to promote public safety. But then we need to commit to those long-term investments that will, the goal is not just to have more people go through the justice system more quickly so remand's not a problem. The goal over time is to build healthier people and healthier communities, so there is less crime to have the system deal with. That is a long and complex problem that we need to work with, but I never came to the conclusion that a set of criminal laws that could potentially be weakened to solve a downstream problem would be the appropriate solution.
All right, well, thank you, Minister, for taking that extra time to assist us here in our work. Thank you for your attendance here today.
If you could pass that note along to the whip's office, I would be grateful.
All right. We're now going to take a short suspension. It'll be just 2 minutes. When we reconvene panel 2, we'll go right till 6:15. It'll be a hard cutoff. We're suspended.